The first case I wanted to talk about, I think I just had one case I wanted to talk about today, and that was it is People versus Whitmore, and it's a California Court of Appeal decision that holds that there is no right to in-person appearances in a sentencing hearing. So the defendant in that case had specifically invoked his constitutional and statutory right to be personally present at the sentencing hearing. But the court held that limiting a defendant to a virtual appearance was legally improper, but it created no harm. And so therefore it was harmless error, and the court affirmed the 10-year sentence. My thought on this was, isn't that structural error? There are certain kinds of errors, like denial of a jury trial, for example, that the Court of Appeal doesn't broach the subject of trying to figure out, well, would it really have resulted in a different outcome if we had given this defendant a jury? We don't even go there. We just say, you had a right to it. This is the way we hold our trials. It didn't happen here. Reversed and remanded, hold a new trial. How am I wrong? Well, hearing no objection.
Yeah, that's an interesting one. One could say you're building in a structural avalanche or tsunami of appeals during COVID if you're going to take the position that a virtual appearance is not adequate. So there might have been a little bit of self-interest by the courts in this ruling.
Yeah, I would think, and the California Constitution says that no judgment shall be set aside unless there's a miscarriage of justice. So we do have this concept of harmless error, and I have to look at that case to see how the defendant articulated the prejudice, because being there, I understand there's a right of confrontation in a criminal trial under the Sixth Amendment, but here this is confronting a witness, is confronting the judge that's sentencing, and maybe the argument is that the court would have felt more sympathetic looking at a live human than a virtual human. And maybe that's the best argument that could be made. And in a matter that's so serious, I don't know. I'm going to have to look at that and see why they said harmless.
So here are the ideas that I could come up with. If I had to face this rule and I had to show that there was prejudice resulting from holding a virtual hearing rather than the in-person hearing that my client was entitled to, I would argue that that maybe there was poor audio quality or a poor connection quality in my Zoom appearance, and you'd have to object early and often if that happened, to make a record of that. Another idea would be maybe if someone is speaking off camera, as happens sometimes, like a clerk, keep alerting the court that it sounds like someone is speaking off camera. I can't hear what's going on. Just keep making a record that there is something unsatisfactory about the way this hearing is being conducted. And then my favorite example, maybe most fanciful example, would be gesticulate a lot. Throw your hands around. Say that I prefer to stand, but I'm going to have to adjust my camera, and just make a record of how disruptive it's being to be able to present your argument in your preferred way.
Yeah, because appellate justices really love reading our briefs, and that is only exceeded by the loves trial judges have for gesticulating counsel that waves arms and rolls their eyes during argument. I'm not sure how I feel about that last suggestion there, Tim.
Well, but this is all I can come up with. I mean, if it's not structural error, I don't know of any way to enforce this constitutional right to an in-person trial.
Yeah, good point. Fair point.